All right, so welcome everybody. Thank you for joining us online today for the launch of the report, The Enforcement of Telecommunication Consumer Protections by the UTS Centre for Media Transition. So I would first like to acknowledge the Gadigal people of the Eora Nation, upon whose ancestral lands our city campus now stands. I would also like to pay respect to the elders, both past and present, acknowledging them as the traditional custodians of knowledge for this land. So this webinar is designed as a short session where the authors of the report will explain central findings on how some key consumer protections mechanisms have been enforced in the telecommunications industry in the period since 2010. This webinar, you can see the topics we plan to cover today on this slide. After explaining the key findings and some aspects of how the research was conducted, the authors will offer some observations on how it helps to understand the broader environment for the enforcement of consumer protections mechanisms in Australia. So please submit any questions you have about the research in the Q&A dialogue box, and we'll get back to them at the end. As this is a Zoom webinar, you won't be able to ask face-to-face. So like I said, it will be short. We aim to do all that in 45 minutes. So let me first introduce the three authors who will each present on aspects of the research. So Dr. Karen Lee, she's a senior lecturer here in the Faculty of Law. Having moved to academia from legal practice, Karen has researched and published widely on aspects of telecommunications regulation. Her book, The Legitimacy and Responsiveness of Industry Rulemaking, provides in-depth analysis of case studies of industry rulemaking in the telecommunications sector. And she has just completed a new project looking at why companies choose to participate in industry association code development. Karen's recent research has also embraced media and digital platform regulation and includes a report with Derek on options for digital platform complaint handling, as well as a 3-year research project funded by the Australian Research Council, The Future of Co-Regulation in the Digital Platform Environment. So that last project is one on which all three of our authors today are working. Dr. Derek Wilding is co-director at the Centre for Media Transition and a professor in the Faculty of Law here at UTS. He was previously director of the Communications Law Centre at UNSW, where he participated in consumer code development through ACIF, the predecessor of Comms Alliance. He then spent a decade in policy regulatory practice, including at the ACMA, the Office of Film and Literature Classification, and the Australian Press Council. At UTS, he led CMT's research for the ACCC on the impact of digital platforms on news and journalism. In addition to his other research with Karen and Kieran, he recently co-edited a book on media pluralism, and is currently part of a 3-year ARC project examining the value of news. Kieran Lindsay is a research officer at the Centre for Media Transition, working on the Centre's Future of Co-Regulation project. He leverages experience from his 5 years as a consultant at a leading Australian strategic communications firm, where he provided advice on media and communication strategy. Kieran's current interests centre on the field of artificial intelligence and the societal impacts of its widespread adoption. So Karen, good afternoon. I'm going to start with a question for you. The report is about consumer protections in the telecommunications sector. What do you mean by that? Can you first explain for us what's in and out of scope?
Sure. So the report, which was commissioned by ACAN, covers what we've kind of loosely coined core consumer protections in the Telecommunications Act, as well as the Telecommunications Consumer Protection and Service Standards Act of 1999. So broadly speaking, we're looking at provisions that relate to the retail experience of consumers. These protections include select industry codes of practice that are registered by ACMA under Part 6 of the Telecoms Act. They cover what Comms Alliance refers to as consumer codes of practice. So here, the TCP Code, the Mobile Premium Services Code, and the Information on Accessibility Features Code. But the report also includes enforcement data related to some operational codes, to the extent that those operational codes support kind of core consumer protection provisions of interest. So examples of the operational codes that we include data about in the report are the IPND code, the reducing scam calls and scam SMS code, and the local number portability code. The consumer protection provisions considered also extend to 4 industry standards determined by ACMA. And these are the standards that relate to mobile number pre-porting, additional identity verification, NBN continuity of service, NBN consumer information, and consumer complaints handling. And then the core consumer protections further encompass service provider rules relating to matters such as CLI, number portability, standard terms and conditions, record keeping, pre-selection, the TIO, emergency call services, kind of quite a lengthy list here, IPND, and priority assistance. And then they also include 4 service provider determinations made by ACMA under Section 99 of the Telecoms Act. So things here we're talking about customer identity authentication, international mobile roaming, NBN service migration, and identity checks for prepaid mobile. And then we've also included some standard carrier conditions as well, CLI, number portability, pre-selection, record keeping, emergency call services. And we've also looked at additional license conditions that apply to Telstra or Telstra InfraCo, so obligations like directory assistance, IPND, etc. The report does not include data on kind of the obligation relating to untimed local calls, the customer service guarantee on things like the universal service obligation, and the report also doesn't deal with do not call or spam provisions, which in the main are largely directed to privacy-related expectations and requirements. And then finally, the report doesn't address the recently adopted Financial Hardship Industry Standard that was adopted after the time period that's the focus of this report, which is looking at the period from 1 January 2010 to 30 June of 2023.
Great. So you've acknowledged in the report that there are some other limitations on the scope of the research and the data available. So we'll come back to the limitations, but for now, can you give us the headline findings?
Sure. So we found 487 public investigations, with all but 26 having enforcement action. We found 309 providers had some form of enforcement action taken against them, and a total of 502 enforcement actions taken by ACMA. Enforcement actions predominantly targeted providers once, with 230 providers being the subject of 1 enforcement action, and 79 providers being the subject of more than 1 enforcement action. The highest number of enforcement actions was taken in 2013-2014, where we saw 115 enforcement actions. That was followed by the 2018-2019 period, where 79 actions were taken, and then 2014-2015, where 64 enforcement actions were taken. So on average, over the 13.5-year period that we were looking at, ACMA took 13.5 enforcement actions per year. The breakdown of the enforcement actions is as set out on the slide there. 296 formal warnings, 119 directions to comply, 41 remedial directions, 24 infringement notices with a total value of just over 6.1 million, 17 enforceable undertakings, 3 civil penalty orders obtained from the federal court, totaling just over $1 million. 1 injunction was obtained from the federal court, and then one deed of agreement. It's important to note that in some instances here, multiple enforcement actions can be taken against a provider for the same breach, and or kind of multiple enforcement actions kind of can be taken or arise out of the same set of facts that gave rise to a set of breaches or breaches. And kind of in other words, effectively enforcement mechanisms can be used in conjunction with each other, depending on the provision breach. So they're not the enforcement actions are not mutually exclusive. We've just tried to provide a table so people could easily kind of get an overview. So for example, in December of, just to give an example here, in December of 2020, ACMA found Leica Mobile had breached the identity checks for prepaid mobile carriage service determination and the IPND service provider rule. And as a result of those contraventions, in January 2021, ACMA gave Leica Mobile a remedial direction, which was subsequently varied in later that year. And that remedial direction was for the prepaid determination. And it also gave the company a direction to comply with the IPND code. In March, it also gave Leica Mobile an infringement notice for approximately $600,000 in relation to the IPND service provider rule, which in this case is a listed infringement notice provision. And then in May, the ACMA also accepted an enforceable undertaking from Leica Mobile in relation to its IPND obligations under the Telecoms Act. There was, in this case, that was just the first round of enforcement action. There was a subsequent round of enforcement, which led ACMA to issue 2 infringement notices in May of 22 for non-compliance with the direction to comply with the IPND code, as well as non-compliance with the remedial direction. And in both instances, they are kind of infringement notice provisions. Okay, next slide, please. So the provisions that attracted the highest number of enforcement action are listed on the slide. The obligations to provide ComCom with compliance attestation document attracted the highest number of enforcement actions of 240 actions. The provision of integrated IPND related information obligations were second. They attracted 73 actions. And of these, 38 were related to the Telecoms Act obligations, and 35 were related to the IPND code obligations. Obligations relating to complaint handling came third with 49 actions. And what I'm referring to the kind of complaint handling provisions here, I am talking about the telecommunications, the Consumer Complaints Handling Standard requirements, as well as the rules that have been set out in the various iterations of the TCP code since 2012. Requirements concerning advertising or provision of information to customers in the TCP code came fourth in our tally. So there we had 35, there were 35 actions involving these. And when I'm talking about the advertising or provision of information obligations here, I'm talking about, the current code imposes rules around the content of advertising, such as the use of terms such as unlimited or free, while, say, clause 4.2 of the TCP code requires the provision of critical information summaries of current offers. And then finally, the requirements to join and comply with the TIO scheme came fifth in our tally, where we saw 28 actions. The high number of actions relating to the requirement to provide compliance attestation document is perhaps explained by the involvement of ComCom in receiving the documentation and reporting on compliance with this obligation. In 2013, after the establishment of ComCom and the commencement of the code, the code compliance framework in the TCP Code, ACMA also undertook a major audit of compliance with these requirements, which resulted in 99 enforcement actions, which consisted of 95 formal warnings and 4 directions to comply. The other obligations that I've highlighted here that are most actively enforced appear on the list, most likely due to their importance to public safety, such as those related to IPND, or the potential scale of their impact on consumer experiences. So here are things like, the TIO scheme, complaints handling, and advertising and information requirements.
Thanks, Karen. So now that we know what emerges from the report, we'll backtrack a little so we can place the research in context. Derek, can you explain how these various enforcement mechanisms fit within some kind of hierarchy or toolbox that's available to the ACMA?
Thanks, Alexia. Yes. So the ACMA has published its own policy on its general approach to compliance and enforcement, and also a series of guidelines that relate to specific tools. Those documents are informative and they're really helpful. They've been helpful in the research that we've done. What we're interested in here is looking at what enforcement tools have been used when. So that brings us to the slide showing these enforcement pyramids. So on the left, the pyramid shows the formal enforcement mechanisms available when there's a breach of a code of practice. And on the right, the pyramid shows the additional tools that are available for the other provisions that we consider here. We should note that these are not general compliance pyramids, which would show at the base of the pyramid the action that a regulator might take to encourage compliance with education and so on, and also informal resolution. So here we're interested in those kind of formal tools. In the administrative category, we've got formal warnings, which can be issued for breaches of a code, standard, service provider, rule, or license condition. We've got a direction to comply, which can be issued for breach of a code or for certain other provisions, for example, the requirements to join and comply with the TIO scheme. An infringement fine, which is on the other pyramid, is for breaches of designated infringement provisions, which includes standards and some of the service provider rules and license conditions that we consider here, but not code breaches. And also a remedial direction, which is in order to take specified action, such as implementing certain operational requirements. We've also included here an administrative category, enforceable undertakings, which need to be volunteered by the provider and which are only available for breaches of the Act, not for code breaches. So finally, in the civil category, we've grouped the following tools, which require the ACMA to apply to the federal court. That's civil penalties, which are only available for specified provisions, including the standards, service provider rules, and carrier license conditions that we consider, and injunctions, which are available for breaches of the Act. So in theory, apply in a broader range of circumstances, but are unlikely to be used where the ACMA has other remedial powers. So taking these aspects of the availability of various enforcement tools with our findings on how often they've been used, we'd say that within the category of administrative actions, there's a further internal differentiation. The first two, formal warnings and directions to comply with codes, can be regarded as the first line response tools. I'll leave it there, and Karen will shortly mention some of the observations that we make in the report about the availability of these tools.
Okay, so while we're discussing the context of the research, I'll now ask Kieran to explain how the team brought all this data together and how some limitations on data access can affect any conclusions that can be made.
Thanks, Alexia. I guess what initially was envisioned as a somewhat straightforward task turned into a pretty time-consuming endeavor. What we set out to achieve, I think we might just go back a slide, Derek. Yep, that one's good, thanks. So what we set out to gather in terms of data were all the investigations carried out by ACMA into the potential contraventions of the in-scope provisions that Karen noted earlier. What we started out with is what's on the slide there as the ACMA table. This was a spreadsheet that ACMA kindly gave ACAN, who provided it to us to start our research. This spreadsheet was based on the list of investigations into telco providers, which is on the ACMA website, and it contained data from the start of 2017 to the end of 2022. So from this table, we removed any entries for provisions that were outside the scope of the report, and then we extended the data to include actions from the 1st of January 2010, and then we also added any newer actions for the first 6 months of 2023. So we initially sourced the pre-2017 data from the ACMA website. That they have a list of enforcement actions or investigations for the period of 2010 to 2016. And we supplemented this with a close inspection of the annual reports for any additional references to enforcement actions. And the newer actions for the first half of 2023 were also sourced from the ACMA website. So, and we might move to the next slide now, Derek. So after we collated all this data, we realized there was a little bit more we needed to add so that it was entirely complete. So for all entries in the 2010 to 2016 list on the ACMA website, there are no investigation reports or enforcement actions that are linked to on the website in its current form. So without these reports, it was a little bit hard to pinpoint exactly the enforcement action that was undertaken or the provisions investigated. So to address this, we were able to cross-reference the information such as the dates, the providers, or the provisions with a number of additional resources which are up there on the slide. So for example, in cases where we had a rough indication of the date of an investigation, we were able to find a number of the missing pre-2016 investigation reports or media releases or other explanatory information through point-in-time snapshots of the ACMA website that were saved through the Wayback Machine or the Australian National Library's Trove repository. Otherwise, we were able to find most of the information from cross-referencing, other materials from the Times, such as ACMA's communications report series, media reporting, some court cases for the civil penalties that we've mentioned, and we're also able to find some information from the TIO or ComCom websites, which aided us. So I should note that the ACMA is not required to prepare and publish investigation reports, nor is it required to maintain a register of all enforcement actions taken against providers. So I guess to keep in mind is that what this means is that our data is based only on investigations that the ACMA has decided to publish. So as a result, we don't have the total number of investigations opened, and we can't say for certain the total number of enforcement actions taken by the ACMA. That being said, as far as I'm aware, this report is definitely the most comprehensive investigation into the regulator's enforcement of consumer protections within the telco sector. So I hope everyone's found the results quite interesting.
Thanks, Kieran. Okay, so taking all that into account, Karen, back to you. What can we say about ACMA's, the ACMA's approach to enforcement?
Okay, and certainly Kieran's right. This is certainly a kind of a new foray into kind of ACMA's investigation activities. But as we identify in the report, there is need for further study to make any conclusive findings or observations. And as we talk about in the report, to fully understand and evaluate the way in which ACMA has exercised enforcement powers would require access to additional information, and that is information that is beyond some of the more kind of basic information gaps that Kieran has just kindly highlighted for us. Among other things, I mean, we would want to be able to conduct some interviews with ACMA staff, as well as the telco service providers against whom enforcement action has been taken. And we would also want to better understand how ACMA's enforcement action dovetails with its own compliance auditing, the internal corporate compliance systems of service providers, as well as the work of the TIO and ComCom. Having said all that, the data collected suggests that that when ACMA does take enforcement action, it acts in accordance with and subject to the limitations of the legislation it's enforcing. It also suggests that ACMA acts broadly in a way that's consistent with its own compliance and enforcement policy, its regulatory guides, and its infringement notice guidelines. Having said that, though, we were left unsure of the extent to which the degree of consumer harm is an element in an enforcement action decision. And we were also left unsure of when and why ACMA would move beyond its first line response of issuing a formal warning and step up with a direction or something stronger where that's where a stronger mechanism is available to it. Certainly ACMA, and as Derek's alluded to, has published guidelines which were very helpful for when it will it kind of indicating for when it will use enforcement action mechanisms, but it doesn't offer an explanation for why it chose one particular enforcement action mechanism over another in any particular case. And certainly the enforcement, the investigation reports that we looked at certainly don't make reference to that, and neither do the actual enforcement action reports themselves. So, and the report shows the report also shows that over the 13.5-year period that's the focus of this report, ACMA has used far more formal warnings than any other enforcement mechanism. Now, to some extent, we think that this is what you would expect, particularly for a regulator that has openly embraced kind of responsive regulation, and certainly the reliance on the formal warnings is consistent with responsive regulatory theory, and that being that you start with the lowest. The lower range of enforcement actions when you're confronted by a provider in breach, you'll use those more frequently, and because many, if not most, but certainly many providers will comply very voluntarily when errors are drawn to their attention. We were, however, surprised by the small number of civil penalties. 3 in total, and we were also surprised by the relatively small number of infringement fines. We understand that infringement fines are designed for circumstances where breaches of rules can be or can be more easily determined, and they're likely to be effective where you have large providers committing a number of breaches of the same declared rule because of the size of its customer base. And we would like to understand why they've not been seen as suitable on more occasions. And the data also provokes questions which we can only canvass. We certainly did not explore, nor did we make any recommendations with respect to these issues, but we nevertheless think that the data does raise some questions about the adequacy of ACMA's enforcement powers, and in particular, whether it needs additional tools, either used in isolation or combination, to secure or motivate industry compliance. So, for example, questions about whether ACMA should have access to tools other than a formal warning and a direction to comply for breaches of codes of practice, whether the value of an infringement fine should be increased to cover situations where a relatively serious single breach attracts a heavier fine. And it also raises the question of whether ACMA should be able to seek, as certainly has been suggested more widely, when you're looking across a multiplicity of industries, whether or not ACMA should be entitled to seek the imposition of criminal penalties for those providers who seriously and repeatedly fail to comply with consumer protection rules. It also, I think, raises the question about whether or not ACMA should have the power to exclude either temporarily or permanently from the market service providers who serially breach consumer protection obligations where where serious consumer harm results.
Thanks, Karen. And so what about the problems with access to information? Derek, perhaps you could address that.
Thanks very much, Alexia. So one of the observations we make in the report, following on from what Kieran was discussing before, is at the moment it's not possible to make a comprehensive assessment of how enforcement tools have been used to protect consumers. So looking forward, what we think is needed to paint this picture would include the following. First, some knowledge of the number of investigations opened and closed each year. So remember, our data set is based on published investigations where there was a breach finding, so a relatively limited data set. Second, we'd like to see information on investigations where there was a finding that the provider did not breach any consumer protection provision, so a non-breach finding. Third, investigations where there was a breach, but this wasn't made public because of public interest concerns. And we're not suggesting here that this principle in itself should be overturned, just that there should be some record of the fact that an investigation was conducted. This kind of analysis also needs access to copies of published investigation reports and enforcement instruments, and explanations for why enforcement action was taken. So only some of this information is on the public record at the moment. And I guess that means, in effect, that only the ACMA itself can make an informed assessment of whether it's a responsive regulator, to use the term that Karen introduced. Now, we're not saying that the ACMA is not a responsive regulator or that there's necessarily a problem in how it's used the tools available to it. We're only saying that it's reasonable to ask the questions that Karen mentioned, such as whether additional tools should be available for code breaches, and for the information needed to answer those questions to be on the public record. Also, there's other valuable work that could be done by researchers or civil society groups to understand the context for enforcement of consumer protection measures. For example, the ACMA has been active in undertaking its own compliance audits on a number of occasions, and these have directly resulted in enforcement action. However, at present, there's only limited utility in examining those aspects because of what's missing in the surrounding context. So this brings us to our recommendation for more of this information to be published by the ACMA, but also for a statutory register that would at least record the details of completed investigations and enforcement actions.
Thank you, Derek. Okay, so thank you to our speakers for the briefing. I'll now turn to audience questions. If you haven't already, please type any questions you have in the Q&A chat box and we'll get to them. I'll just give you a few moments to do that. If you do have any questions after this webinar, I encourage you to contact Karen on karen.lee@uts.edu.au. I do have a question here. So it was mentioned that breaches of codes only have administrative penalties. However, a failure to comply with the direction to comply is a breach of the Act. Has the report considered the full process of compliance?
Yes, I think I was the one who mentioned that particular action. And yes, indeed, in that chapter of your report, there's a mention of the second level of what the additional tools that are available for breach of, say, an order, a direction to comply, and how those additional options are available to the regulator at that time. And indeed, there's a Sankey diagram that Kieran has put together, which kind of links those subsequent actions back to the original breach. So if there's an action that's taken as a result of that second level, we trace that back to the original breach, and it's represented in a table within the report.
Thanks, Derek. We've got another question here from Teresa Corbin. Was it clear if there were any ACMA actions that were taken due to self-reporting by providers? Also, does the panel think there is a role for self-reporting?
I'll have I have a few things to say about this one. Because we didn't have access to all of the kind of investigation reports and whatnot, Teresa, we weren't able to determine necessarily which whether or not action followed self-reporting by the provider. I think we did, from memory, we did see a couple situations where I think it was a case Optus, but please don't quote me. I need to double check, where we did think that so there was at least one case where that is mentioned and touched on briefly in the report, but we weren't in a position to track that through, and that wasn't necessarily a question that we were able to answer in this report with the scope and the funding for the research. As far as do we think that there is a role for self-reporting? Certainly, yes. Kind of in the regulatory literature, I think there is an important role for self-reporting. The extent to which that is adequately reflected or ought to be taken into account when enforcement action is made, I think, is certainly a relevant factor. I think it's certainly, if you're going to adopt a responsive regulatory approach, you do want providers to come forward and be honest where they have made mistakes, and you do need some form of framework in which to facilitate that. But as far as on the academic literature side, I must say I have not come across too many specific articles dealing with that specific question, though.
Great. I've got another question here from Eric Erickson. So with the relatively small numbers of actions you report over such a lengthy period and rapidly diminishing numbers of complaints recorded by the TIO, doesn't this indicate the success of co-regulation?
I think you probably need to be a little bit careful. I don't think we could confidently come to a conclusion along those lines at the moment. Certainly, the report is not just looking at code enforcement. It is looking at the full suite of enforcement actions, and we have not, in this report at any rate, isolated kind of or look specifically at kind of codes that is something of interest to us, to me and Derek, as part of the wider project that we are doing on digital platform regulation. But certainly at this moment, I don't think the report speaks one way or the other to the statement that you've made there, Eric. Derek, I don't know if there's anything you'd like to add.
Okay, thank you. If there aren't any further questions, we'll wrap up today. Thank you all very much for your time.
Okay, thank you. Thank you for joining us.